It's sitting. When we took the adjournment, the lunch break suspension, we were dealing with private members' motion number 1. The leader of the opposition had completed. So, does any other member wish to speak? The Honorable Deputy Governor.
Mr. Speaker, thank you. Mr. Speaker, I will be short, but I do want to make a few points. Mr. Speaker, first I want to thank the member, the Honorable Deputy Leader of the Opposition, for bringing the motion. I think it's very important for our country, for people to understand and appreciate how we feel about the provisions in our Constitution that speak to who can run for office and who can vote. And I think we all agree that the current provisions are fair and that they should remain. Mr. Speaker, I have been Deputy Governor now for almost 9 years. Time has flew by. And I have had the opportunity to work with, I think, 4 governors, and from time to time I have worked with the FCO. Mr. Speaker, I just want to say a few things. First of all, Mr. Speaker, I have never, during my tenure, had any conversation or heard any debate about the Cayman Islands having to or should change their voting provisions in the Constitution. I've never heard that argument during my time as Deputy Governor. But Mr. Speaker, there was a time in the early 2000s when we were being criticized for not allowing persons who had been in our country for an extended period of time to have security of tenure. Mr. Speaker, I believe it was your government that addressed that situation when you passed amendments to the immigration law that brought in term limits. Yes, sir. And rightly so, Mr. Speaker, because we did have persons living in our country for 20, 25 years without security of tenure. There was nothing to prevent someone from staying here for even longer on a work permit. And this Parliament decided to address that issue, and we brought in term limits, which means that we introduced a graduated rights system so that a person, upon reaching year 8, had the ability to apply for permanent residence. Once they obtain permanent residence, then they could apply for naturalization within 1 year, and 5 years after being naturalized, or if they had been resident of the island for 15 years, they could immediately apply for the right to be Caymanian. Mr. Speaker, as a result of that law, there's only, I would think, because there are some persons on appeal for various immigration decisions, but the vast majority of persons who have been in this island in excess of 15 years are a Caymanian. So this Parliament has taken the necessary steps that I believe was necessary to address the concerns of the UK government at that time. Some bold decisions were taken, Mr. Speaker. The term limits were not popular. No one wanted to be told that they could only stay in the island for 8 years. I think the term limits were 7 years, and then you had a key employee provisions. So, Mr. Speaker, if the Deputy Leader of the Opposition read the UK government's response, and it said, the UK government continues to believe in the importance of allowing people who have made their permanent home in the territories the ability to vote and engage in the community. So, Mr. Speaker, if you look at that opening paragraph or opening sentence, I believe, Mr. Speaker, is that the Cayman Islands has addressed that concern. We also believe that people who have made Cayman their permanent home and has become a Caymanian should be allowed to vote. However, we hold dearly who can stand for office. That is completely different. You need me to repeat what I said?
Yeah, you need to repeat.
Okay. I said that the UK government, in their response, says the UK government continues to believe in the importance of allowing people who have made their permanent home in the territory the ability to vote and engage fully in the community. My view is, let me finish please, is that the Cayman Islands is compliant with that paragraph in that we have provided an avenue for persons who are residing permanently in this island, who have been granted the right to be Caymanian. We've provided that Caymanian. No, I said it from the very beginning. Okay, I did, but that's, okay. I'm not going to argue. I said it, but I'll say it again. Those who have been granted the right to be Caymanian has a right to vote. So, Mr. Speaker, I believe the Cayman Islands is compliant with that particular paragraph. So we are not, in my opinion, offending any of the beliefs that the UK has put forward. We have that ability now. And I also just want to also put forward, as the deputy leader of the opposition said, that in the response, the UK did say, while they were pushed to give a timeline as to when they would be dealing with these issues, that they did not intend to publish a timeline. So, Mr. Speaker, I can only speak from experience and from where I sit in terms of Deputy Governor, the conversations that I have had with the governor, previous governors, how we, and I want to emphasize that, Mr. Speaker, the Cayman Islands, in my opinion, has already done what was necessary to address the concerns of the UK government. We have put in place a very clear and straightforward system which allows persons to go from being a work permit holder to being a Caymanian. Not everybody's going to get it, and we refuse many applications for permanent residence. We refuse applications for status. We refuse applications for naturalization. We do it all the time. But there is a system in place that allows persons who are in our country permanently, who are a Caymanian, we are allowing them to take part as a voter. So, Mr. Speaker, I just want to make those few points. And again, I thank the member for bringing the motion. And I thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak?
Because I fear that's real fear. That's my fear. Because you can have residency without going to the other step. I fear that.
Last call. Does any other member wish to speak? If not, I call now on the Honorable Deputy Leader of the Opposition to do his closing remarks.
Thank you, Mr. Speaker. Mr. Speaker, I don't want to snatch defeat from the jaws of victory, but
The what?
there there are some comments that have been made during this debate that I have to address before I wind up, but I'll try to be quick about it. Mr. Speaker, the Honorable Premier, in his support of the motion, started to question or raise a question about the difference between ruling and declaration. And I think he missed the point I was trying to make when he was making his arguments. Because going back to the same-sex marriage
So I do have to sign on it.
trial in the courts, the courts made a ruling on same-sex marriage. However, in making that ruling, they made a declaration that the two individuals were entitled to some legal protection. And it had to be corrected in the law. And the process for that, Mr. Speaker, is to send the responsibility back to us, this legislature. And Section 23 of the Constitution makes that quite clear, Mr. Speaker. Declaration of Incompatibility 23:1. If in any legal proceedings primary legislation is found to be incompatible with this part, the court must make a declaration recording that the legislation is incompatible with the relevant section or sections of the Bill of Rights and the nature of that incompatibility. 2, a declaration of incompatibility made under Section 1 shall not constitute repugnancy to this order and shall not affect the continuation in force and operation of the legislation or section or sections in question. 3, in the event of a declaration of incompatibility made under subsection 1, the legislature shall decide how to remedy the incompatibility. And Mr. Speaker, just to touch on what the Premier was saying, the courts didn't recommend a solution. That was left up to this legislature. What then happened was the bill came to this legislature. It was not supported. It was voted down. And then, in keeping with the Premier's promise to us, the governor acted within a week. Now, or just about a week. Now, that situation should not have come about. What should have happened is the legislature should have found a solution. Clearly, the bill that was presented was not acceptable. And it would have been up to us, if process had been followed, to find the appropriate solution, but that didn't happen. We went straight to Section 81. So, the Premier was challenging me on my legal knowledge. Mr. Speaker, I'm not here as a lawyer, I'm here as a representative and a politician. This is the house of politics, it's not a courthouse. And I'm still a law student. And I want to make something clear because I know this is going to come up during the campaign. I already heard the little warning signs. I don't spend my days in the law school. I study by distance learning, and I do that late at night when everybody else is asleep, or most people are asleep. So I don't want anybody to make the assumption, based on the Premier's comments, that I'm spending my time in law school and not doing my work. And that was, I undertook law school to become a better representative and to know more about the law, because I'm a lawmaker. So I just want to make that clear from now, because it's still a season. I see the campaign has started, and I've heard little utterances about me being in law school. It's distance learning. It's not Cayman Islands Law School. So I have hopefully clarified what I was trying to say, and I think the Premier misunderstood, or deliberately so. I know sometimes he likes to throw these things up to try to throw you off track with your argument.
You would know anything about that?
No, I wouldn't know anything about that. Thanks, member from Prospect, for confirming my approach to politics. Mr. Speaker, Premier also talked about the new Section 81 and what transpired and what caused the FCO to change their mind, the UK to change their mind on the new, or making changes to Section 81. But I have to agree with my colleague, the Leader of the Opposition. I know the Premier thinks it was a great loss. That was the one change that I found that I had to reluctantly support, because the new 81, in my interpretation, and I stand to be corrected if anyone wants to correct me, would have given the governor the ability to come to this legislature to address us in order to push a particular agenda. But when would that sort of action be required? It could only be during instances when there was a disagreement between the cabinet and the governor. Because if the executive and the governor are in agreement, there's no need for the governor to come here to address this legislature and try to get support for something. It would just follow the natural course the way things are done now. So I saw that new 81 as potentially opening the door to a governor becoming a politician and lobbying members of this honorable house to support a position against the wishes of cabinet and against the agreement of cabinet. So I didn't see that as any great loss. I would have loved to have seen 81 removed entirely. And Mr. Speaker, I went with the Honorable Premier, along with the member from Northside to England, and we negotiated those changes, and we talked about negotiation. We walked away with an agreement of what was going to be changed, and now we're hearing that they've changed their mind and they're going to do something else. That is not negotiation in my mind. That is heavy-handedness. So, Mr. Speaker, I don't see any great loss. I disagree with the Premier on that, because I don't think anybody wants the governor to get involved, too embroiled in our politics. We do a good enough job of that ourselves. But what this motion is about, and again, the Premier questioned whether or not what the motivation was, because we don't want to mislead the country and make them believe that this vote here today will be the end of it and nothing more will come. No, that's not what this motion is about. This motion is about us standing united as a legislature to say we are not going to support this, and we will fight against it if it comes. That is what this motion is about. And there's a lot of uncertainty now in our communities, in our constituencies, over what has transpired here. And if you don't believe me, ask your constituents. We have people who are on edge, very concerned about the future of this country because of what has happened. And that uncertainty has to be answered by this legislature. So that is why I decided to bring this motion, Mr. Speaker. We have to show the country that we're willing, as we did when we went to the UK, united, and fought for changes to our constitution that would move us forward, take this country forward, take this legislature forward. Together, well, this is one of those issues that we can't afford to be divided on. Mr. Speaker, I hear the Honorable Deputy Governor in his contribution and his assurances that in his experience, this is not something that is going to be pushed. And I appreciate him getting up and saying that. It provides a bit of relief to the concerns. But, and in the Honorable Deputy Governor's view, we are compliant with the requirements or the recommendation in the FAC report based on what we have done with our immigration regime. But, Mr. Speaker, I am a bit more cynical. Maybe it's almost 8 years in politics. And I look at the same FAC report and recommendation for the sanctions and anti-money laundering, well, the beneficial ownership that was triggered by an amendment in the House of Commons. And we were compliant, I think, almost 100% with all the requirements that had been put on us then in terms of our financial services and what we were doing. But what came next was an amendment that is forcing beneficial ownership registers on us, even though we were compliant and being good corporate citizens and leading the financial services in over many other jurisdictions who are part of those nations that criticize us. We do much better than them with complying with legislation and requirements, much better. Yet we were singled out and the overseas territories were targeted. So, Mr. Speaker, we even got blacklisted by the EU, despite all of our efforts. And while I know the Premier does a lot of traveling and promotes this country and promotes the financial services, so does the Minister, despite all those efforts, we still got hit. So I'm a bit more cynical because of those experiences. I wish I shared the Honorable Deputy Governor's optimism, but as my good friend from East End always says, trust but verify. So, Mr. Speaker, as I said earlier, I was disappointed that we didn't make, and the Premier talked about this, we didn't make our position abundantly clear to the FAC when asked. And I know the Premier says that he doesn't respond to them for whatever his reasons may be, and he doesn't feel he has to be under their, be questioned by them, I think is the way he put it. However, Mr. Speaker, the FAC is not to be ignored. The FAC, as my colleague said earlier, was very instrumental in events in Turks and Caicos. And they are influential to the point that the United Kingdom government responded to the report. It wasn't discarded or ignored. There were responses made. And then, Mr. Speaker, for our governor to refer to that report in a press release justifying his actions tells me that we need to be wary. I would be the happiest person in the world, Mr. Speaker, to be proven wrong. Mr. Speaker, in the Cayman Islands, we are all working as hard as we can to offer protections to Caymanians, employment opportunities, and other opportunities for our people. If there's a question mark over belongership in these islands, assumptions can be made over what our position really is, and I'm trying to avoid such an eventuality. I don't want anyone to assume anything on our behalf. I do recall the Honourable Premier making very strong statements in the UK, with regard to the UK. And I printed out a lot of quotations and articles that quoted him, but I won't belabor that point any longer. However, he did make very strong statements with regard to belongership. And while he made those statements publicly, I think today is a good day for us to affirm exactly what he said. Any proposed changes to this arrangement, Mr. Speaker, have to come through referendum. There's no way that any sort of change in the whole belongership regime that we have in place could come any differently. And I do note that the FAC report talked about those who reside permanently, and I interpret that as permanent residents. So that perhaps they should clarify if there's any difference. Mr. Speaker, as I outlined earlier, we were forced down the road of civil partnerships. This legislature didn't get the opportunity to resolve that on our own. Aside from the one debate where we disagreed on how to get there, because we all just agreed that we had to get there some kind of way. However, I don't want this country to become the first to be forced into belongership changes for British overseas territory citizens and UK citizens who have not gone through that rite of passage to become a Caymanian, to have the rights and privileges of those who have. It's our duty to safeguard these islands against such an imposition, because the effects on our social, economic, and demographic makeup would be dramatic is a light word. Just think of the inequality that would create here. We have people who come here from Jamaica, Honduras, Philippines, United States, Canada, all over the world. But such a change would single out British overseas territory citizens and United Kingdom citizens and give them more rights than those other nationalities who come here, work, struggle to make a living, make a life, and eventually earn the right to become Caymanian. And we would be giving them, British overseas territory citizens and UK citizens, those rights without them having to earn it. Everyone else would have to wait. As a matter of fact, in terms of standing for election, you'd have to wait a generation. But what the FAC is proposing, I read quite differently. Think about the effects on the economy and employment if these individuals could arrive here and start to immediately as they step off, not immediately, but as they become permanent residents, go down and get their voter's card. I don't like to play guessing games, Mr. Speaker. I like things to be black or white. And making our position clear on this would avoid any of those diplomatic games and play on words that I often read in these reports, where true intentions are hidden quite often. The governor found some justification in using Section 81 through his Section 55 powers, Mr. Speaker. At some point, he could find a justification, or any governor, not just the current governor, to find a justification for belongership through Section 55. So let's have this conversation now, and let's speak loudly here today. We have no real representation in the UK Parliament. Our representation is here. When that Sanctions and Anti-Money Laundering Act amendment was passed, nobody spoke up for us. Well, some did. But we see the end result. You think about the unfairness of the proposal. I was talking to the Honorable Attorney General yesterday about lawyers. We accept UK lawyers here. They go and get admitted. But our lawyers that are trained here, educated here, can't go to the UK to practice. It's those sorts of inequalities that make me cynical and untrusting with this current arrangement. Mr. Speaker, For those, I'll say this once, aspiring to be in a position of leadership in this country, to be in the driving seat, in the premier seat, I just want to remind them that seat is not custom fit. You have to grow into it. You have to fit into that seat. Yesterday, the government refused a proposal I made in a debate to protect Caymanians against employers who were illegally dismissing Caymanians. Today, my message is, let's show the country that we all have the mettle to do what we were elected to do, to represent our people. This country is going through an economic crisis. We're going through some social issues. And now is the time for strong leadership. In my opinion, the actions that transpired quite recently with the Civil Partnership Bill should never have been tolerated by a government. Now, I won't get into the rule of law argument and all that. I won't revive that. My opinion, if it were me, I wouldn't tolerate it. However, our silence on this matter will determine what happens next. And so, those few words, Mr. Speaker, I'm asking everybody to think loudly, clearly, on what I've just said. We have an election coming up. Clearly, the Premier has signaled the start of the campaign, and the people are looking to see who's willing to stand in their defense and to represent them. As my colleague from East End pointed out, the governor's job is not to look out for us. It is to look out for us as long as it doesn't interfere with what is best for the United Kingdom. That is not unconditional love. That is divided love. What we offer our constituents has to be unconditional love. And we must always stand on this side. And when I say this side, I mean this side of the Atlantic. I know you're getting tired of hearing me, but I'm not going anywhere. Everything is peaceful until the Premier comes back into the chamber, Mr. Speaker. I was just winding up, but now he's encouraging me to continue talking. Anyway, Mr. Speaker, he's trying to be nice. So I will wind up now by saying, let's just stand together today on this one issue and make sure that we send a loud, clear message that this issue cannot become an issue. Thank you.
Question is, be it therefore resolved that this Honorable House do affirm to maintain the requirements to be registered as an elector and the qualifications for elected membership of the Legislative Assembly as expressed in sections 90 and 61 of the Constitution, respectively. All those in favor, please say aye.
Aye.
Those against?
Mr. Speaker, can I have a division, please?
No, not yet. I will grant you that, but those against? The ayes have it. The member from Georgetown Central.
Mr. Speaker, can I have a division, please?
Clerk, divide, please.
Honorable Alden McLaughlin.
Aye.
Honorable Juliana O'Connor Connolly.
No?
Honorable Moses Kirkconnell.
Aye.
Honorable Juliana O'Connor Connolly. Aye. Honorable Dwayne Seymour. Honorable Roy Mike Tigert.
Aye.
Honorable Joseph Hugh.
Aye.
Honorable Tara Rivers.
Aye.
Captain Eugene Ebanks.
Aye.
Honorable Barbara Connolly.
Aye.
Mr. David White.
Aye.
Mr. Austin Harris.
Aye.
Honorable Ard McLean.
Yes.
Mr. Alva Zaku.
Aye.
Mr. Kenneth Bryan.
Aye.
Mr. Anthony Eden. Mr. Christopher Saunders.
Yes.
Mr. Barney Bush.
Yes.
Mr. Ezra Miller.
Aye.
Watch me. The results of this division are 16 ayes and 2 absentees. Therefore, the motion is carried. Let it be recorded that the Speaker is in support thereof.
Mr. Speaker, I beg your indulgence. I apologize, but if I was here, I would have said aye.
We understand that you came in just as the vote was taken. Under the rules, if you're not in your seat, then your vote is not counted, but we understand where you are. Standing orders, serious need of revision.
Yes, sir.
Private member motion number 2 of 2020-2021. Compliance. Ah.
Honorable members, this morning we agreed that at some point we would return to questions to allow the elected member for Georgetown Central to ask questions number 5 and number 6 to the ministry, to the Honorable Minister of Education.
Questions to the Honourable Ministers and members of the Cabinet. The elected member for Georgetown Central to ask the Honourable Minister of Education, Youth, Sports, Agriculture and Lands. Question number 5.
Member for Georgetown Central.
Thank you, Mr. Speaker. I rise to ask the question on the order paper standing my name, number 5. Can the Honorable Minister say whether an executor of a will is allowed to take a loan or a charge against a property for which they are responsible for, and if so, what are the restrictions or limitations for doing so?
The Honorable Minister of Education.
Thank you, Mr. Speaker. Thanks to the honourable member. The answer: the execution and administration of wills in the Cayman Islands is governed by the Wills Law 2020 revision and the Succession Law 2006 revision and the Probate and Administrative Rules 2008 revision. Thank you.
The member for Georgetown Central.
Thank you, Mr. Speaker. For myself and the listening audience, the Cayman people, can the minister refer to what sections of the law and what those sections say in respect to the question?
Honorable Minister of Education.
Thank you, Mr. Speaker. If I would kindly draw your attention to Standing Order 22. G, a question shall not solicit expression of opinion or the solution of an abstract legal question or be hypothetical. And subsection H10, the answer to which can be found by reference in available official publication. I would ask the question to be out of order on those reasons. May it please you.
The member for Georgetown Central.
Mr. Speaker, it seems as if my goal and intention with this topic has been circumvented through the standing order process, which is the rules and regulations of debate in this Honorable House. So I have to accept this loss and move on to my next question.
The elected member for Georgetown Central to answer Honourable Minister of Education, Youth, Sports, Agriculture and Land. Question number 6.
The member for Georgetown Central.
Thank you, Mr. Speaker. I rise to ask the question standing in my name on the order paper number 6. Can the Honourable Minister say when will all government schools teachers receive the increase to their salaries to meet the proposed minimum wage of 5,000 CI dollars in accordance with the government's announcements?
Honorable the Minister of Education.
Thank you, Mr. Speaker. Thanks to the honourable member. The answer: as of September 1st, 2020, all government teachers have received the promised $5,000 as their remuneration.
The member for Georgetown Central.
Thank you, Mr. Speaker. Can the Honourable Minister say whether the teachers at the University College of the Cayman Islands have also had their salaries increased to the $5,000 of the government's policy?
The Honourable Minister of Education.
Thank you, Mr. Speaker. Mr. Speaker, the UCCI is an independent body that is run by a board of governors, and they make their decisions as it relates to remuneration, salaries, and benefits. We do buy outputs from them, and the honourable member will see that in the upcoming appropriation bill, without infringing on the rules of anticipation, has an allocation to give them what we are responsible as far as the ministry is concerned, which is the COLA, and that allocation will come under Section 12.
Member for Georgetown Central.
Thank you, Mr. Speaker. Can the minister say then that is the university teachers not considered to be teachers in respect to the government's policy? Regardless of whether it's a non-profit organization, are they considered to be separate and apart and not important to the education of our Caymanian children?
Honorable Minister of Education.
Thank you, Honorable Member, and thank you, Speaker. Far be from it, Mr. Speaker, the Minister, as in myself and indeed the government, which I'm honored to be a part of, would never say that as education is of paramount consideration and forms a formidable part of our not only campaign, but our modus operandi. But there is a separation of power. They are run by a board of governors, and this minister certainly has not operated whereby I attend the meetings or I orchestrate them as if they're puppets. We've chosen very independent intellectual professionals to deal with the operation of UCCI together with the most capable and able president, Dr. Stacey. And I have every confidence that as funds become available within their own budget, they themselves value the value of teachers and will act accordingly. If they are short of funds and they come from time to time, they are prioritized for capital projects and other aspects. For example, when we had a meeting, Mr. Speaker, it came to my attention that they were unable to specifically identify where students were with their grades and how they could best augment that. So I was able to get the agreement of Cabinet to give them the necessary funds to get the software to enhance that. And that is what the government does. We fill the gaps accordingly, but we don't get into the day-to-day operations of the independent body.
The member for Georgetown Central.
Thank you, Mr. Speaker, and I want to thank the Minister for her responses. Can the Minister say, have the Cabinet, through the Minister, advised or encouraged the governing body to bring in line the pay, salaries, and scales of the lecturers at the university to be in line with that of the government's policy?
Honorable Minister of Education.
Thank you, Mr. Speaker. Mr. Speaker, by virtue and by the operational capacities of PAL, the Public Authorities Law, there is not a necessity for the minister to do that because there's a statutory obligation, and I can confirm that POX and UCCI Chairman, Dr. Stacey, and others, along with ACO Joel Francis, have been working for some months now to look at the whole salary range and see how they can best be realigned. What I cannot say at this stage is what is the final outcome of that, but I know that tremendous work has been going on in that regard.
A member for Georgetown Central.
Thank you, Mr. Speaker. I guess I'll be following that up in Finance Committee in the future. Can the minister say whether in the upcoming budget, whether there's been sufficient enough funds allocated in that budget to secure that all lecturers who are owed their COLA or were notified that their COLA increase would come up is covered in that budget supplementary that we're going to be speaking about in the sitting of the House?
Honorable Minister of Education.
Thank you, Mr. Speaker. Mr. Speaker,
This is the last supplementary. Not talk, you got to ask a question. Honorable Minister.
Thank you, Mr. Speaker. What I can say is that there's an allocation to deal with the outstanding COLA, and it's not, as I understand, it's not like they've not been receiving it. You have to do various, or let me just leave that because I don't want to anticipate the appropriation bill, but what I will do is to undertake that when that item comes up on this Section 12 in the appropriation bill, that my staff will be here, including UCCI, so that we can get both people talking from the same hymn book, because I would say it's much better for UCCI to take the normal route to getting their allocations as opposed to be questioned through supplementary.
Last supplementary, the member for Georgetown Central.
Thank you, Mr. Speaker, and I thank the minister for that, because ultimately what I'm trying to do is just to ensure that the staff and faculty at the University College is appropriately funded to bring in line their salary scales, because they are two very important to the educational process of our children in this country. So I look forward to that line of questioning with all persons involved to be here to answer appropriately, but just to hope that there's enough funding allocated in the budget so that they can address that financial issue in respect to the salaries of the staff at the University College.
Honorable the Minister of Education.
If I may beg your indulgence, just to say that the Minister look forward to disseminate information about education or any aspect of our ministry, because we are transparent and accountable, and those who have been keenly observant in the past 3 years, the Minister of Education has put teaching profession way up on the totem pole, and I don't think there should be any question to that regard. And if I were to be political, but I refrain from being it, some of the former politicians just about now would say, if there is need for more money, then we'll look at the respective constituencies and see how we can get the money to increase it.
The Honorable the Leader of the Opposition.
Mr. Speaker, I wonder if the Minister can tell us when if the legislature will be presented with the new school governance structure that is anticipated for 2021.
The Honorable the Minister of Education.
Mr. Speaker, thank the Honourable Leader of the Opposition for that very loaded question, and I welcome this opportunity to so respond. He would be fully aware that I have delegated the responsibility to my very able and competent Education Council chaired by Mr. Dan Scott to create a subcommittee and pull in whatever necessary private sector, public sector resources that they need to review what is necessary to do a pilot program in the beginning to see how it was going to run. And they are, as I understand it, I think the council met one time, there was some discussion. The Honourable Premier mentioned it yesterday that it's still the intent of the government as to when it's going to be delivered would be tying the hands and the extensivity that I expect the chairman to do, who's very detailed chairman, including Mr. Darrell Rankin, who also sits by his side to enable that the work is carried out. But seeing that the House will be prorogued on the 16th of March, I suspect that I may not be the Minister of Education at that time. So I would defer that for the person responsible.
Private member motion number 2 of 2020-2020.
The member for George.
Lost.
Clark. You called? The next item? Yeah. Yeah, but he was Kenneth was he just come back.
Private member motion number 2, 2020-2021, compliance of section 119 of the Cayman Islands Constitution, to be moved by the elected member for Georgetown Central.
The member for Georgetown Central.
Thank you, Mr. Speaker. It's been such a long time since I actually did a motion. I forget the process now. Mr. Speaker, I rise to move the motion standing in my name on the order paper number 2, compliance with section 19 of the Cayman Islands Constitution Order 2019, whereas the Cayman Islands Constitution, Order 2009, the Constitution, Section 119 states, subject to this Constitution, a law enacted by the legislature shall provide for the establishment, functions, and jurisdiction of councils for each electoral district to operate as advisory bodies to the elected members of the Legislative Assembly, and whereas the Advisory District Councils Law 2011, which was created by your administration, was assented to by His Excellency Duncan Taylor on the 1st of February 2011, and whereas Section 4 of the Advisory District Councils Law 2011 requires that the Governor and Cabinet appoint the members of each Advisory District Council, and that the Governor and Cabinet shall be cognizant of the recommendations made to him from within the electoral districts, and whereas Section 8 of the Advisory District Councils Law 2011 states that the Governor and Cabinet may make regulations for the proper and efficient carrying out of the functions of the Council, and whereas to date the appointment of members of the Advisory District Councils and the creation of the regulations required to properly implement the law has not been completed, be it there further resolved that the government considers immediately completing the process required to fully implement the Advisory District Councils Law 2011 and the proper operation of the Advisory District Councils.
Is there a seconder? The Honorable the Deputy Leader of the Opposition.
Thank you, Mr. Speaker. I rise to second the motion.
The elected member for Georgetown Central.
Thank you, Mr. Speaker. Mr. Speaker, in prompting one of our future debates, the first thing I'm going to ask for is a new stand, so the opposition can talk from a strong position like the Premier. I can use that one too? No, I've been using that for too long. I might get that bad behavior from him. I just joke at you. Mr. Speaker, I'm not going to go too deep in my opening debate because, Mr. Speaker, we all know in this country, or most people would know, what the district councils mean to our society and what it means to democracy. And most of us would know that in our change in our constitution back in 2009, much debate and discussions went down in respect to putting this provision in the Constitution to ensure that the people had their say. And in your administration, Mr. Speaker, you did what was necessary to implement a law to allow for the people to have their say through direct democracy, through advisory district councils. And up to now, we haven't seen a council created legally. So, Mr. Speaker, I think that the government is well aware of the intent of this motion, and there really do need to be much debate. It's pretty simple and straightforward. We have in our Constitution that we should have district councils. We created a law in 2011 to have district councils. The government has the power to create and appoint the memberships of the district council, and they haven't done so. This motion is simply asking them to do exactly that. So, Mr. Speaker, I'm not going to do much more discussions and allow the government to have their say, if they have any, in respect to why they haven't done so, or if they intend to do so, and allow any other member of the House to have their say in respect to it. And I will address or respond in the appropriate manner, depending on the responses by this honorable House.
Does any other member wish to speak? Does any other member wish to speak? Last call. Does any other member wish to speak? The Honorable the Premier. Yes, I quite understand.
Mr. Speaker, thank you, and thanks, thanks for the indulgence. I hope I'm not losing my voice. I got a lot of speaking left to do in this meeting. Mr. Speaker, the matter of the Advisory Districts Council Law 2011. This was assented to by His Excellency, the then Governor Duncan Taylor, on the 1st of February back 2011. But I've asked the AG to just check to make sure, but to the best of my knowledge and recollection, the law has never been brought into effect. A lot of water has gone under the bridge since 2011, including the increase in membership of the House and the move to single-member constituencies. When that law was devised, there were only 6 electoral districts. In addition to there being perceived to be operational and indeed policy concerns around the makeup of the councils, which would, the present provisions of that law allow the government to appoint members to all district councils, all. The provisions of the Advisory District Councils Law allows the government to appoint members to all district councils, so that the government is represented on all district councils. There were obviously some, let me use a nice word, reservations among members in the opposition about that. But beyond that, structurally, I think the law needs to be reconsidered, because we now have 19 constituencies. So the government agrees that the matter needs to be reviewed, and the only bit of the resolution which we would struggle with is the prospect of immediately completing the process. This House has, and members have 5 months left in office, and now we believe is really not the time to be focusing on creating advisory district councils. I believe, Mr. Speaker, that this is properly the work for the next administration. And so, as I say, we really don't want to vote against the motion, because The law does need review. It is just the bit about immediately that we will struggle with. Thank you, Mr. Speaker. I should say, if the member is the member for Georgetown Central is inclined to amend the motion to with just deleting that one word, then we can accept the motion.
Does any other member wish to speak? Does any other member wish to speak? Ask all. The Honorable the Deputy Leader of the Opposition.
Thank you, Mr. Speaker. Just briefly, because as a seconder with this motion, I wanted to rise to give my support to what the member from Georgetown Central is asking for. Mr. Speaker, I believe that there have only been 2 district councils attempts to create what you would consider district council. Since this law was passed, I think the member from Northside has his council, and I have made an attempt to create a council as well. But of course, without the law behind it, without the law behind it, you're limited quite a bit to what you can do. And of course, without the regulations in place. So I do see this as something that is pressing, something that is required, and something that is a requirement of our democracy. And I hear the Premier. I hear his reasons for not doing it now. However, we have had quite a bit of time to get this done. We can't make these important aspects of our Constitution, we can't put them on hold till when it's convenient for us. We may or may not be here after the next election. We don't know. Time waits for no one, and we have to we have to continue to evolve and put things in place as the Constitution requires them. We can't say that we're going to wait until a more convenient time. Mr. Speaker, the district councils are a fundamental aspect of our democracy. It empowers the people in our constituencies to work along with us, to advise us, to help the communities. We recently went through a lot of arguments and back and forth about rule of law, Mr. Speaker. And I will leave that to my colleague from Georgetown Central to expand upon. I'm pretty sure he will. But if we're talking about a jurisdiction that follows the rule of law, well, this is one example where we're failing. So, Mr. Speaker, I wholeheartedly support the creation and implementation of district councils. I think that it can be done in fairly short order. I don't think that it carries with it a whole lot of cost, additional cost to the country at this time. I know that we're able to draft legislation very quickly. Regulations can be produced extremely quickly. We've seen that through COVID. So I think this is something we should just get done. Whether we agree or disagree on the merits of district councils, Mr. Speaker, the Constitution called for it. And we have to respect that Constitution. So I rise to support the members' motion, and I ask all honorable members to please also give their support, because this aspect of our democracy is something that was approved by the people of this country in a referendum, and it is something that has been hanging for quite some time and just needs to be done. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? Does any other member wish to speak. I'll call now on the Minister for Financial Services.
Thank you, Mr. Speaker. Mr. Speaker, I rise to make a very brief contribution. Mr. Speaker, I think it is obviously the Premier has acknowledged the position of the government with respect to willingness to support the motion, but the difficulty obviously from a logistical perspective, from a timing, and the word immediate, and obviously he's put forward what the offer on behalf of the government has been to the member with respect to his consideration. But, Mr. Speaker, forgive me, I'm actually trying to scroll through the actual legislation or the Constitution itself, because I think it's important to show that whereas we hear a lot about district councils, we've heard a lot about district councils. It's that time of the year again, it's that season again where we'll continue to hear a lot about district councils for various reasons, and in this case stating the obvious for political reasons. It is important though that people understand what it is that the Constitution is actually calling for, and appreciate that some of what has been said, some of what may be said, some of what is to come to be said regarding the role of district councils, or in this case, advisory district councils, it is important to appreciate what that is. And the idea that the individual members are hamstrung for whatever reason by doing whatever consultation, by having and taking whatever advice from their individual constituency councils without having this framework legislation is somehow null and void, I think, Mr. Speaker, is a bit of a stretch. And I say that because the Constitution itself, and I'm still scrolling here, the Constitution itself just says, and I quote, the call in the Constitution under Section 119, Advisory District Councils. Subject to this Constitution, a law enacted by the legislature shall provide for the establishment, functions, and jurisdiction of councils for each electoral district to operate as advisory bodies to the elected members of the Legislative Assembly. So the members that have spoken before are absolutely right. It is in our Constitution, and therefore it is something that we as a country should move towards putting in place to be in compliance with the Constitution. I think there is no doubt that that is an acknowledged fact. The fact that the original framework doesn't fit the current framework of our governance structures and therefore needs to be amended, that has also been acknowledged. But, Mr. Speaker, if you look at I said it as was said before, the law was written at a time where we didn't have single-member constituencies, and so therefore there's some areas that we would need to kind of amend in order to be able to make the law better fit for purpose, I believe, with respect to what we're trying to achieve. But, Mr. Speaker, not wanting to read the entire District Council's law as it's stated now, the functions of a district council essentially can happen irrespective of having that piece of legislation. The role, the responsibilities of a district council, it's very possible that each and every member in this chamber, if we wanted to establish such a council, it is possible to do so, and I think we all need to be very honest with accepting that position. So waiting for a framework piece of legislation and understanding that it is a constitutional requirement. Nobody is saying that that is not the case. But using that as an explanation for why you yourself may not have such a council is something that I think we need to make sure that we don't create this idea that because we don't have the legislation in place now, we can't have such a council. We do have examples of members in this chamber who have a functioning council, be it in formal title or formal recognition. They still provide what is the primary essence of what this body calls for, and that is advice. It is an advisory council. It does not have any binding legislative or other decision making. It is an advisory council to the member, and therefore it is important that we don't create an impression that's beyond what the role and function is, as important as it is. So I just wanted to be very clear that we support, and I certainly support the idea and the concept and ensuring that we do have a framework that is in place because it is in our Constitution, but it also does state it's an advisory council, and the functions of that advisory council is carried out in many respects on a day-to-day basis by many community committees, etc. And so from that perspective, saying that we don't have this law means that individual members is not in a position to have such a council, I think is a bit of a stretch. So I just wanted to put that on record, Mr. Speaker, because I know you yourself have a council of sorts, whether it's called a council, a committee. Many of us have our own individual committees, and to use that term, however we deem it, that we seek counsel and we seek advice. So from that respect, I think, Mr. Speaker, there is certainly no objection from myself and as the Premier said, from the government regarding having the framework legislation in place. It's just a question of timing at this point. So I just wanted to help to elucidate what the role and responsibilities of a council, and especially an advisory council, as is expressly stated in the one line in the Constitution. Thank you.
Does any other member wish to speak? The member for Prospect.
Thank you, Mr. Speaker, and certainly thank you to the honourable member for Georgetown Central and the honourable deputy leader of the opposition for bringing this motion. I too wish to rise to give support for the motion at hand, but I would like to seek to offer some degree of clarification on the motion itself, but also, as was done by the Honourable Minister of Financial Services, likewise point to the constituency of both Prospect and Red Bay, who may not have a district council by definition of the law itself, but by all means it does in fact have a community group that serves to be advisory to the representatives, namely the Honourable Premier, who has responsibility for Red Bay, and myself in Prospect. So we do have an operative form of advisory district council, albeit it goes by a different name. And very effective, if I might add as well. And certainly the openness of communication is very much alive in both Prospect and the Red Bay constituencies. However, Mr. Speaker, it is on the point of correctness on the motion itself that I wish to draw your attention to, again with the view of seeing this motion passed. Reading from private member's motion number 2 in the third paragraph, the third whereas, it says, Section 4 of the Advisory District Council Law 2011 requires the governor to appoint members of each advisory district council. Mr. Speaker, just to draw your attention to the fact that this motion and the wording of the motion is in fact contrary to what the wording of the law itself says. Section 4, subsection 1 of the Advisory District Council's Law 2011 reads, a council shall consist of the following members, all of whom shall be appointed by the governor in cabinet. The wording in the third whereas, as it begins, suggests that As the private member's motion is worded, it would otherwise give the reader the assumption that the governor himself is making these appointments, but the law states governor and cabinet, and by that definition, it is referring to a decision of the cabinet and not so much the decision of the governor, small g. Now, I recognize the members, both the mover and the seconder, went on to acknowledge this as that sentence or paragraph concludes, where it says, and that the governor and cabinet shall be cognizant of recommendations made to him from within the electoral districts. I just think for correctness, Mr. Speaker, again with the view of seeing this private member's motion passed, that we should amend the wording in paragraph 3 to include the words governor and cabinet who is making that appointment. The governor and cabinet? All right. Well, again, I defer to perhaps the more legal minds in terms of the operation of, what the law states and certainly what the rules are that obtains. However, to be consistent in the wording, I believe it is important to see that the wording is amended in the motion. Again, Mr. Speaker, with the view of seeing this motion passed and supported by this House. Thank you, Mr. Speaker.
Does any other member wish to speak? Does any other member wish to speak? I call now on the mover for his right of reply.
Mr. Speaker, I beg your indulgence to have a short break so myself and the Honorable Premier can have a chat on his offer to make the necessary amendments. I think that we could find a reasonable compromise that the good people of Cayman will get their district councils in a timely manner. But I see that he's indicated that the word immediately is problematic for the government. But without a time frame, I'm not sure I can agree to that. So do you mind breaking for 5 minutes to have that discussion?
Thank you.
Honorable member for Georgetown Central, I will have to defer to the Premier.
Mr. Speaker, I don't want to waste anyone's time, let alone, least of all, members of this House. I did say in my contribution, it is not something the government would get done during this term. This is the middle of October, November, December, January, February. The 29th of March, the House is dissolved. We got just over 5 months. It's unreasonable for me to, and it would be misleading for me to suggest that with all of the drafting that is lined up for the AG's chambers to get done, that this is likely to get done in that time. And I don't want to mislead the member or the House or the public about that.
The member for Georgetown Central.
Thank you, Mr. Speaker. I'm a bit disappointed, Mr. Speaker, that the Premier has chosen not to put a priority on this. And I was really hoping that just a 5-minute break to talk about it, because this is a very important. Well, I guess you have already clarified that you have no intention of doing it before the end of this administration. That is unacceptable to me. So if that's Mr. Speaker, would I crave your indulgence, because this is very important, to allow us to have that 5-minute break, please.
If the Premier is agreeable, and you and himself is going to meet. Then I would pray that the meeting of minds will come out with a solution that says that they agree at some point in time. We will suspend proceedings till it's 5 minutes over 4:15. 4:15. Sorry? Well, I think it will take more than 5 minutes. We would suspend proceedings till 4:15.